Oyez, oyez, oyez. All persons having business before the Honorable, the United States Court of Appeals for the District of Columbia Circuit are admonished to draw near and give their attention, for the court is now sitting. God save the United States and this honorable court. Be seated, please. Case number 22-3025, United States of America versus Edward McGruder, appellant. Mr. Searby for the appellant, Mr. McGovern for the appellee.
Mr. Searby, good morning.
Good morning, Judge Henderson. May it please the court. Bruce Searby appearing for appellant Edward McGruder. I'd like to reserve 3 minutes of my time. And as far as a roadmap, I'd like to accomplish 3 things with my opening. First, I'd like to emphasize Mr. McGruder's argument relating to the liberal standard for withdrawal of his guilty plea under Rule 11D based on the warrantless search of his backpack where heroin was found, which argument his attorney missed, and to this day the government has offered no evidence establishing a justification for this warrantless search. Second, I would like to turn to the Louisiana warrant that we've raised. I'd like to disclose, under my duty of candor to the court, new information that the government has brought to my attention just in the past few days that could be seen to undercut appellant's argument about the Louisiana warrant. And third, I'd like to argue to you, notwithstanding this new information, that Mr. McGruder deserves to withdraw his guilty plea based on a defective Louisiana warrant and his counsel's failure to raise that below, or at least get a remand to develop the record. So starting on the first point, the backpack. The government has never offered evidence justifying the warrantless search of Mr. McGruder's backpack, and his counsel who advised his guilty plea was constitutionally deficient in failing to pursue a motion. And the district court abused discretion in denying his chance to withdraw his guilty plea and to pursue and explore suppression of the backpack search. There were, in this case, no facts showing that agents were already in the process of arresting appellant for a drug conspiracy when they searched his backpack. It would be unprecedented, and this would let loose, frankly, laziness and utter disrespect for the warrant requirement if this case went the government's way.
When you say that there's no facts showing that the agents already knew something at the specific time of searching the backpack, are you suggesting that they needed to have told Mr. McGruder right then and there, or what are you getting at with respect to when someone should have known about that?
I'm sorry, Judge Childs. What I was trying to say is that the agents were not already in the process of arresting Mr. McGruder when they did the backpack search. It's not what they knew. That's not the issue that I'm pointing to right now. It's what they were doing. Agents were not already in the process of arresting Mr. McGruder. Therefore, you cannot bring in the search incident to arrest doctrine, which is exactly what the district court agreed with the government about, that justified the warrantless search.
And what about the months-long ongoing investigation that was occurring in Louisiana that brought us forward to that date, as well as the various warrants in that regard?
That did not create probable cause for the arrest on a drug distribution and possession with intent to distribute charge, which is exactly the only reason that agents arrested Mr. McGruder after searching his backpack. That all had to, what you just mentioned, all had to do with a drug conspiracy in several months prior. Now, what agents really did is they wanted to search Mr. McGruder's backpack. They were not in the process of already arresting him for a drug conspiracy, which is what the government now seeks to do, to bring in this search incident to arrest the doctrine.
So you're saying that despite that they had all this information, meaning the Louisiana contingency of police officers, investigators, et cetera, knew that Mr. McGruder was making these trips from DC to New York, and that on that particular day, this trip was consistent with the information that they had previously had, that you're saying that these agents did not have any of that information available to them, despite that this particular trip was similar to other trips that he had made that they were aware of?
No, Judge Childs, I'm not saying that. I'm saying that they did not have probable cause to arrest the defendant for a drug distribution charge or a drug possession with intent to distribute, which is what they actually arrested him for. They also do not get to use the search incident to arrest doctrine, which is an exception to the warrant requirement based upon this drug conspiracy evidence that they had accumulated.
Even if they start out with whatever is part of the months-long investigation and they have an ability to arrest based on the fruits of that particular investigation for a specific charge, but then they come upon him and there's something else they see, are you telling me that they can't arrest for something different?
Yes, Your Honor. There was no probable cause at that point for them to arrest based upon possession with intent to distribute, and cases cited by the government for the proposition that they can still use the search incident for arrest doctrine are distinguishable. They're distinguishable because of what I started saying, which is that agents were not already in the process of arresting the defendant for a drug conspiracy when they searched his backpack. Therefore, that line is
And I'll move
irrelevant.
off of this, but I'm still trying to get where are you getting that agents were not in the process of arresting him when they are there apparently based on information that they've had in Louisiana that is consistent on that day with all of the same information from before. So where are you getting that they were not there that day to do the same thing, that something's compatible with what was going on in Louisiana?
Well, my point is that there was absolutely no evidence in the record ever to this day that they were there to arrest him on a drug conspiracy charge supported by the evidence that you're referring to. They were not doing that. At least there's no evidence in the record that they were doing that. Rather, the only evidence in the record is the complaint affidavit of one of the arresting agents who said that he gets off the bus, they search his backpack, and then they arrest him. So there's absolutely nothing entered into the record by the government supporting this idea that they were actually there to arrest him on a drug conspiracy charge.
Could they have arrested him?
What's that?
Could they have arrested him on a drug conspiracy? Did they have probable cause for that?
They did have probable cause for months old drug conspiracy.
I'm not asking
conduct.
the agent, I'm asking you just an answer to the question, direct
Yes,
question.
they could have.
Arrested, they could have arrested. So there's no question that they could have arrested him right then and there.
They
And
could have,
searched
but
him.
they weren't going to until they found the drugs pursuant to the search.
Well,
So-
that's a lot of subjective intent that we don't normally get into in probable cause inquiries. So if probable cause existed, as Judge Childs has been discussing with you, to arrest him, then there was cause to do a search incident to arrest. And we have case laws, do many other courts, saying that the before after doesn't matter as long as they are very proximate in time. And if you agreed that he had probable cause, what is your best case that the probable cause has to be for the specific crime for which he is subsequently then charged?
Your Honor, because in the brief that we filed, in the reply in the opening brief, we distinguish all those cases that you're referring to. And the Rawlings case is distinguishable. There, the defendant had already confessed to a crime by the time the search was made, that the police, based on that
I understand,
confession.
you've agreed that they had probable cause to arrest and therefore search at the time they approached him and took his backpack. They already had all of that. So and I appreciate the careful distinctions in your brief from these other cases. I'm just asking, what's your best case that since they had probable cause to arrest and therefore search, it is somehow dissipates or is no longer sufficient because of their subjective intent to arrest for a different.
Because, Your Honor, that makes a difference. The intent of the officer makes a difference in all these cases. They're in this line of cases that the government now wants to rely on. And so if you read Rawlings, if you read Powell, if you read the other cases that we carefully go through, it does matter what evidence there is in the record of what the officers had been doing before and what they had been going to arrest the person for. So it's absolutely essential, and the distinction that I'm pointing out is critical. All the government had to do below.
We would have to adopt a subjective intent test to write an opinion for you. We would have to say, for these purposes, if you want to do a search or a search and then arrest, want to reverse the order, then subjective intent is controlling.
Your Honor, I think actually you'd have to do the opposite, which is create a whole new layer of exception to the search warrant, to the doctrine that you need a search warrant. And if you don't, you can do it search incident to arrest. Now there's this line of cases about the exact timing of events. This case would push that and extend that way too far, Your Honor, by disregarding what the officers were intending to do before the search.
You keep saying intent, so there would have to be a subjective intent element to the test that you want us to adopt.
Yes, Your Honor. And in these other cases, the record below in the district court had been fully developed so that you could have an exploration of what the officers were actually doing and what they were thinking and why they pulled someone over, why they searched somebody, why they had detained somebody. So this case is exceptional here because there's the only facts in the record go the other way. They go appellant Magruder's way, which is to say that the search appears to have been triggering the arrest and not some imminent arrest triggering the search. And that makes all the difference in the world because search incident to arrest exception is based upon things like danger to the police officers. They're about to make an arrest. And so even though they formally do it a little bit later, they still have the search incident to arrest doctrine available to protect themselves. So rather than us on the appellate side adding a new requirement, it's actually would be just loosening this doctrine that comes out of cases like Rawlings and Powell and Bookhart. These are all distinguishable for the reason that I've stated.
You think you had information about the Louisiana warrant argument as well?
Yes, Your Honor. First of all, the government informed me a few days ago that in fact, the first counsel for Mr. McGruder did receive the Louisiana warrant prior to the plea. Now, we would still say, of course, that there's an argument there for appellant. I just want to say that there is a big difference between Mr. Crawley, who is the court-appointed counsel who advised the guilty plea, receiving the 2018 Louisiana search warrant from the government on the one hand, and on the other, now actually reading it and actually exploring the issues presented by that Louisiana warrant. So we think that it's not as I put it in the brief that Mr. Crawley never got the warrant from the government. But it's still the case that he evidently didn't do anything with it, maybe didn't even read it, and that new counsel came into the case not knowing, not having the warrant and needing to get it later. Now, just as to the point that the Louisiana warrant matters, I think that it hinges in terms of the court's jurisdiction to issue the warrant on this proposition that there was a connection between Mr. McGruder and the jurisdiction of Louisiana, and that ultimately there's somebody in Columbia who was the source of both Mr. McGruder's conversations and the drugs in Houston and Louisiana.
The affidavit talks about there's multiple people involved, and it seems to be focused on delivery of drugs into Louisiana.
Right.
And this other person shows up, Tony, with this phone number.
Right.
And probable cause is not, it's not a super high standard. It's a substantial standard, but it doesn't. You can have probable cause, and it turns out not to be factually accurate at the end of the day. But that's not. We don't look at it in hindsight. Why wasn't there on the face of that affidavit probable cause to think that he was part of this group that was operating in New Orleans?
Because the agent who is in charge of presenting adequate probable cause, the only thing he had is the following phrase: "It is believed that so-and-so in Columbia is the source."
Mm-hmm.
Now, Your Honors, if anyone came to you and argued It is to
But I'm not
believe,
going
it is
to read that one
believed.
paragraph in isolation. You, when you read the whole affidavit, it's about multiple individuals. So it's clearly a multi-individual operation that is definitely has a nexus to Louisiana. And the affidavit reads as though, and yet here's another person that's talking to the same guy. And so why isn't there at least probable cause there to think that he was part of this Louisiana operation? Given the surrounding context in which they hear Tony talking, they identify the phone number, they hear the same types of conversations about drug dealing, that to say this, he must be part of this too.
Well, because there's actually no link between Tony and Louisiana,
He's
except
talking
through
to
this
of the
one
people who's
individual.
involved. Well, yes, but that person is involved in dealing drugs in New Orleans. So again, it wouldn't be proof beyond a reasonable doubt by any means, maybe not even a preponderance. Or why wasn't it probable cause to think he was part of this grouping?
There
was
wasn't
working in
probable cause of
Louisiana.
it. That's my point, which is that,
I
Your
know, I'm
Honor,
asking
Your
why
Honor,
that's not probable cause, that here's someone else who's talking to the same person who's dumping all this stuff in Louisiana.
Your Honor, there's not probable cause that the same individual talking to Tony was involved in Louisiana. There is the bare assertion that it is believed that, passive voice, we don't know who, we don't know when, we don't know why. It is believed that's it, plus one, apparently maybe one phone call placed by the Louisiana connection in Columbia. So there's nothing there. There's certainly no probable cause, even under a light standard, for making this connection. And they don't cite any evidence like you need when you go in and you're trying to establish a critical fact like this jurisdictional nexus. There's just nothing but it is believed that this man was the source. And the court cannot honor that as probable cause without opening the floodgates for the government to do very, very minimal work to establish its case in these search warrants, and without turning the government loose to just assert, well, it is believed that this, it is believed that that. In this case, that nexus, that's all it hangs on to. Plus, apparently, at some point in time, somebody called that same person, and Tony called that same person. That's it. Thank you, Your Honor.
I'll give you a couple minutes in reply. All right, Mr. McGovern.
Good morning, Your Honors. May it please the court, Michael McGovern on behalf of the United States, appellee in this matter. After Mr. McGruder pled guilty pursuant to a plea agreement that his own counsel admitted gave him substantial concessions from the government, he engaged in protracted litigation to withdraw that plea agreement before the district court. Over many months, the district court considered each and every one of his claims, and in a series of 4 orders, written orders, rejected each and every one of those. Now, Mr. McGruder is before you on appeal, advancing only 2 claims, one of which he never presented before the district court, and the other of which was presented but is entirely meritless. Because the first claim was never presented before the district court, and because the second claim is meritless, the district court did not abuse its discretion, which is the standard for evaluating the denial of the motion to withdraw, when it denied that motion to withdraw. Turning first to his new claim on appeal regarding the jurisdictional nexus of the 2008 warrant that was issued in the Eastern District of Louisiana. That claim was never presented to the district court. It's not properly before this court. There was no development of the record regarding what his counsel, the only way in which—
We often have ineffective assistance of counsel arguments raised in direct appeals for the first time on appeal for obvious reasons. It's a new attorney on the appeal, and we haven't treated those as forfeited in the past, have we?
No, Your Honor. So on a direct, and I'd like to point out that Your Honor correctly noted, majority of those decisions are in the context of a direct appeal. Here, we're talking about the direct appeal of a motion to withdraw. So—
Yeah, but it's still the direct appeal in his criminal case. That was denied, final judgment was entered. This is a direct criminal appeal.
Correct, Your Honor.
So I don't think how that's any
I
different.
think I would distinguish this situation where there is an appropriate vehicle where he could raise a 2255 based on this claim and then be subject to appropriate procedural
Well, his
bars.
argument is the two attorneys in district court did not raise this issue. And so we're ineffective. There was no attorney in district court to raise their own self-ineffectiveness,
But
which is why we allowed it to be raised here. And then we decide whether there's merit or potential merit or not. If there is, we can remand for fact-finding. If there's no legs to it, we can deny it. But I don't understand why this is a direct criminal appeal by a claim of ineffectiveness raised by a new attorney about the trial attorneys. And if your argument is we expected the trial attorneys to raise their own ineffectiveness, is that what you mean?
well, here, given that there was new counsel for the motion to withdraw, yes, because
But that person didn't identify this problem either. That person didn't identify the ineffectiveness of the prior attorney.
which may be a ground for overcoming some type of procedural bar in a proper 2255 motion, but that would
You're
require
gonna
the
say it's
development of the record.
forfeited when an attorney does not ineffectively fail, let's just assume there's ineffectiveness. If an attorney ineffectively fails to argue ineffective assistance of counsel, we're going to say it's forfeited on direct appeal? When have we ever done that?
I have not seen a case in which they've done that. I also haven't seen that in the context of a motion to withdraw, which
I understand why a
occurred
motion to withdraw
after.
would be different. If his argument here is that neither attorney below raised this and should have, and even more so now, if in fact they actually had the Louisiana warrant, I just don't understand. I mean, we can proceed to other aspects of this argument, but
Absolutely.
we've never
And
treated
Your
that as
Honor,
forfeiture. We don't expect ineffectiveness to be raised by the attorneys who were alleged to be ineffective. I'm not saying anybody was or was not at this point, but that's the issue before us.
yes, Your Honor, I understand your point. This court has said in the context of appeals of collateral attacks that where a ground for ineffectiveness hadn't been properly raised, it can't be then raised on appeal. I would analogize a motion to withdraw similarly, especially where they were represented by another counsel. But I take Your Honor's point, and turning to the other aspects, there's no need for remand in this case because there is no merit to the allegation that there was no jurisdiction to issue the 2008 Louisiana warrant. That is because in Louisiana, agents were investigating a drug trafficking ring that was actively distributing drugs in Louisiana. There had been an indictment of certain of those individuals. Through wiretaps, they had identified the go-between who was in Colombia, who was providing the directions on how to pick up and how to pay for those drugs. And through a wiretap of that individual that was conducted by Colombian investigators, they tied that go-between to another member of a drug trafficking organization based in Colombia that was responsible or that was the supplier for the drugs in New Orleans. Through the wiretap in Colombia, they also picked up conversations Mr. McGruder was having with the higher individual in the drug trafficking organization in Colombia. And on those facts, those agents had probable cause. There was a reasonable inference to be drawn that the drug trafficking organization that had contacts with Louisiana was distributing via drugs into the United States via Mr. McGruder. And because of that,
Into the United States or into Louisiana?
was involved in a conspiracy to distribute drugs, which included overt acts distributing to Louisiana, which it had established through.
Where does the affidavit lay out probable cause to think that Mr. McGruder, Tony, in the affidavit was distributing to Louisiana? What facts?
I don't believe that what the jurisdiction over the offense being investigated language would require is to show Tony's own overt acts in Louisiana. The requirement is that there be jurisdiction over the offense. And in a drug conspiracy, that offense can be charged and there's jurisdiction to investigate it.
Right, so if this helpful, you can clarify for me, was he being, I just don't see this in the affidavit for some of the reasons your friend has said on the other side has said. Was he being investigated? Or was the offense under investigation for purposes of Mr. McGruder, the delivery of drugs into Louisiana? Or conspiracy to bring drugs into Louisiana? Or was it, as you said, conspiracy to bring drugs somewhere into the United States?
The offense under investigation was the drug trafficking of the Colombian drug trafficking organization, which had known ties to Louisiana and which had known communications with Mr. Magruder.
So
And
the
it-
offense under investigation was bringing drugs into Louisiana.
Yeah, yes.
I mean, if you have, I'm trying to understand how you read the word jurisdiction in the Stored Communications Act. So it was, the offense under investigation was a conspiracy and maybe actual acts of delivering drugs from Colombia into Louisiana.
Correct.
And where is the connection in the affidavit to think that Tony with a 202 area code was part of that operation or a different operation, not yet being investigated, of bringing drugs into other places in the United States?
There was a connection between the supplier, a known supplier of drugs to New Orleans, was supplying another individual whose whereabouts were unknown, who had a 202 area code in the day of mobile phones. I don't know that that actually provides very much information for anyone as to location. And so at that point,
So
it's
they
a
thought
reasonable
Tony-
inference that the conversations between Tony and the Colombian drug trafficking organization were related to that Colombian drug operations conspiracy to distribute drugs, which included, for that drug trafficking organization, the distribution of drugs into Louisiana.
That would all make sense if the affidavit, and I understand the argument completely. I don't understand why the affiant did not say then, we think that he is part of this operation because he's talking to the same head honcho or
Well-
delivery guy or whatever his title was.
And I apologize that I don't have the language directly at my fingertips, but they did state that they were investigating, that they believed that further information on this, the geolocation, would give them further information on the crimes that were being committed by those three. And they listed the individuals in New Orleans, the individuals in Colombia, and Tony. And so I think the reasonable inference from this is that they believed the information that they would receive would be information relevant to their investigation of the New Orleans drug trafficking organization. Even if Tony was a separate spoke, they were investigating the hub, the drug trafficking organization in Colombia. So information regarding Tony could be relevant to the New Orleans drug trafficking, as it could have provided evidence in any number of ways that could potentially be admissible, even in a drug trafficking prosecution that didn't have to do with Tony. So I think that's what I'm trying to decouple is Mr. Magruder's argument is that we needed to establish Tony could be responsible for crimes in New Orleans before we can even look at his information. And I don't think that's what's required under the Act. I think what's required under the Act is that there be jurisdiction over the offense that they are investigating. And when they're investigating a drug conspiracy to import drugs into New Orleans, and they have a wiretap where an individual is discussing receiving and drug proceeds and providing drug proceeds and picking up drugs and dealing with drugs, that provides a sufficient nexus for them to explore that further and to gather that evidence, because that evidence, there's a probable cause that evidence would be relevant even to just the New Orleans trafficking organization.
Well, defense counsel indicates that when you are on the ground right there in DC with respect to Mr. Magruder, there's no evidence in the record about what you knew, with respect to him. And it's only at the time that you pull him aside and search his backpack that you then come into anything that is potentially criminal. Can you just respond to that allegation?
So I think I would disagree with that, Judge Childs. Turning to the probable cause argument that he has made, it's very clear that a judge of the District of Columbia who issued a wiretapping warrant determined that there had been previous indication of, or there had been a previous finding that there was probable cause that Tony was involved in distribution, a conspiracy, money laundering, and use of communication facilities to facilitate drug trafficking. Those probable cause determinations had already been made, and as he conceded in response to Judge Millett's question, there's no doubt that there was probable cause for those agents. And as the discussion with Judge Millett continued, there are cases that stand for the fact that where that probable cause exists and where there is a basis for that arrest, we don't look at the subjective intent of those FBI officers as to which particular crime they are necessarily arresting for. I would argue that there is nothing in the record that indicates those officers weren't arresting him for the crime that he committed. I believe there was probable cause to believe that he was transporting drugs at that time. He was engaged in physical travel, which was entirely consistent with the physical travel he had been engaged in previously for the prior crimes that the judge had found probable cause to believe was possession of narcotics and drug conspiracy. So I do believe that there was probable cause for the crime itself that was charged. But we don't look post hoc. We don't look at what ultimately was indicted. We look at the time of the arrest. Was there probable cause for them to arrest him for something? And I think one final point I'd like to make, I see my time is up. Defense counsel noted that the arrest was triggered by the search rather than having been engaged in first. And I don't think there's anything in the record that supports that. And because this is a motion to withdraw after there's already been a plea agreement, it is his burden below to show both deficiency and prejudice. So he has the burden to show prejudice, which means he has the burden to show that there was some Fourth Amendment violation. And it's not a reasonable inference that these officers who had engaged in a months-long investigation of this individual would do a takedown and not intend to arrest that individual. I think it just doesn't make sense. And there is nothing in the record that indicates that they had anything but an intention to seize drugs the next time he went to New York. In the warrant where they sought the geolocation itself, and this is on page A148, they specifically said that geolocation service will assist them in effecting a seizure of the drugs because they believed he was going to travel to New York again. And that is exactly what they did. When he went to New York, they arrested him and seized those drugs and charged him with the resulting crime. If there are no further questions, we'd ask to affirm.
Thank you. Again, Judge Childs, I am not denying that agents knew a lot about Mr. Edwards by the time he got off the bus. I'm making an argument about the applicability in this case of the search incident to arrest doctrine and how it is being stretched beyond recognition, beyond prior precedent to apply to a crime that, notwithstanding counsel's testimony today that there was a takedown going on, there is actually no evidence that when he got off the bus, they were intending to arrest him for a drug conspiracy for which they had evidence from, and they did have evidence of conversations. They had been following him, but there's no evidence that they were intending to do a takedown right then. But they certainly did, as
Why
described.
be there? Why be there? I mean, why even be, and I'm referring to the agents at the train station or whatever, if you will,
To do a search.
waiting on this particular individual.
Just to do a search. And that's exactly what they did. And they found something and then they arrested him. And there's no, and counsel is doing a bit of burden shifting here when it's actually the government's burden to justify a warrantless search. And there's no evidence in the record supporting a search incident to arrest under any of these cases because of what I've been describing. So I just wanted to clear that up because we have other reasons for disputing that search than the ones that you think I have. Now, I would like to go back to the Louisiana warrant, and you can see from counsel's argument right now how dependent he is on this notion that the person talking to Tony was the source of the drugs for the others, and how dependent he is for that being the way to establish the jurisdiction of the Louisiana court to issue that warrant. And my point laser focuses on that connection, because I'm not saying that the only way to establish jurisdiction in Louisiana over Mr. McGruder's activities would be to have him running around Louisiana. I am saying, however, that what they They don't have that, that's for sure. They don't have him running around Louisiana, any connection between him directly in the Louisiana case, but they also can't really establish this link through Columbia, except by asking the court to say, you know, it's okay to say it is believed that. And counsel keeps referring to him, to this Colombian as the source, as the supplier, but it all comes down to faith that somebody, someone out there, sometime, for some reason, had arrived at the right conclusion that he was the source for the Houston and New Orleans drug conspiracy. And that is way too thin. That is not probable cause, and a trained agent would know that.
Well, he says, I believe, based on training and experience in these conversations, not just that we're discussing the trafficking of multiple kilograms of cocaine and heroin. And he talked about the sort of language, the code language that was used, and then says that given that he's talking to the same guy about the same drugs that are being moved into Louisiana, that the geolocation information will be evidence of Tony's membership in the drug, not a drug, the drug conspiracy. And the drug conspiracy is one that the Louisiana court had jurisdiction over.
Your Honor, there's nothing but the belief of someone out there that this person was the source. There's a belief and one phone call, perhaps, at least one phone call.
They had multiple phone calls that they thought this person was the source of the drugs that were going to the other people, Acho and other, there's too many names here for me to keep straight.
No, Your Honor, no, not multiple phone calls. No. And that's my point, is that we don't know when at least one phone call was placed connecting up this chain of people. And if you look at it closely, there's just, as I put it in the opening brief, just a gossamer thread established factually between these people. And other than that, it's just this belief.
Agent, and you haven't, I had understood you to challenge this. One of the probable cause allegations is that Mascara Asperia was the Columbia-based supplier in coordination with Cashew, who is a part of the Louisiana drug conspiracy.
That's exactly.
Probable cause, obviously this is a probable cause. All right, and you haven't disputed that.
I have.
Okay,
I have disputed that.
The Mascara, so I thought your argument was it wasn't probable causes to Tony. You're saying there's not probable causes to Mascara Asperia either?
I'm saying that connection through the Colombian, and there are two mascaras involved here, but
I know, but
the
Asperia
Colombian
is
that
the one that was the supplier.
according to the government and according to someone's belief, Your Honor, that's precisely the point that I'm challenging here, which is that the government wanted the magistrate judge, and now wants this court to believe that that person was the supplier in Houston and Louisiana. But if you look at
They've
what
already
they
got a
offer,
separate warrant on Mascara Asperia. I mean, I don't know how you can read this affidavit and say there wasn't probable cause to think that there was a basis for tapping Mascara Asperia's phone as the supplier of drugs into Louisiana through the other individuals, Mascara Amari or Cashew. And then this other guy shows up on the phone and they say, well, we think he might be part of he's having the same coded conversations. He's having coded conversations, and so we think he's part of the drug conspiracy.
Your Honor, there are two mascaras. There's Mascara
I
Amari
understand.
and Mascara Asperia.
Yes.
And by the way, the government also tries to introduce later search warrants as to the link with Mr. McGruder or Tony. And the court should not be looking, no court should be looking to future later search warrants to establish probable cause for the one that issued. So I'm not.
Prior one. I'm very confused as to your argument. Let me understand that your argument is that they didn't even have probable cause to think that Mascara Asperia was the source in Colombia and to have a warrant on his phone?
Not presented in this affidavit, Your Honor.
Okay, I thought your whole argument was about probable causes to Tony.
Oh, no, I'm glad I cleared that up. No, what my brief says is that the link between Tony and the search warrant, the investigation in Louisiana, goes through Colombia and goes through this person, Mascara Asperia, who it is asserted in this is the source of what's going on in Louisiana. However, if you examine the facts introduced here, there's completely insignificant support for that proposition, repeated again here today over and over. And if you look at that, what factual support the affiant put into that proposition, that the person talking to Tony was the source for all these drugs going to Louisiana, there's just not a significant amount of information. And this court cannot be permitting search warrants to issue with key elements such as the jurisdictional nexus being established by statements like, it is believed that, because that's all they got. And we cannot let
It's
agents
not
do
all I've
that.
got. There's a lot of facts about coded conversation, who's calling who and who's talking to who when.
That's all that brings the jurisdiction together, Your Honor.
Got it.
That's,
I understand your argument.
thank you.
All right, Mr. Serby, you were appointed by the court to represent Mr. McGruder. We thank you for your assistance.
Thank you, Your Honor.
Case number 22-5235. Roger Hall and Study Solutions Results, Inc., Accuracy in Media, Appellant versus Central Intelligence Agency. Mr. Clark for the appellant, Mr. White for the appellee.
Let's wait till the courtroom clears. All right. Mr. Clark, good morning.
Yes, good morning, Your Honors. John Clark on behalf of the appellant, Accuracy Media, Inc. In this Freedom of Information Act lawsuit, the plaintiffs seek records on American prisoners of war held in Southeast Asia during and particularly after the Vietnam War was over. On January, I will endeavor to, we have raised 5 issues. I will endeavor to briefly touch on all of them. But before I do, I think it's important to look at the background of this case because it is relevant to the determination of the issues that the appellant has raised. On January 23, 1973, President Nixon announced to the country that the Vietnam War was over and that all of our boys were on the way home. It was not true. A few days later after that, the chairman of the Joint Chiefs of Staff, Admiral Thomas Moorer, received a list of POWs to be released. And when he received that list, it was so deficient that he ordered an immediate halt to the withdrawal of troops from Vietnam. So this controversy is now 50 years old. And this lawsuit that we were here for is 20 years old. Over the course of the last 50 years, there have been 2 executive orders mandating release of these records, in addition to a presidential directive which stated, entitled Declassification of POW MIA records, directing all executive branch agencies to complete the review by Veterans Day of 1993. In 1992, the researchers determined that almost the exact number of POWs left behind, and that was 678. Now, we have raised a number of issues. One of the issues, probably the main one, is the existence of positive indications of overlooked materials. And under Valencia, a 1990 case, which relied on the 1979 case, Founding Church of Scientology. And those cases held that summary judgment is not appropriate, where the record raises issues of substantial doubt as to the search of positive indications of overlooked materials. I suggest to the court that here we have the positive indications of overlooked materials is just enormous. In plaintiff's October 2016 statement of material facts includes 153 statements that reflects really an enormous body of records which have neither been identified nor produced.
When was the last Senate or House hearing on this topic?
1992 Senate Select Committee on POW/MIA Affairs.
Does the exception for searching operational files that have been the subject of a congressional hearing, does that apply even if the hearing was 30 years ago?
It would apply, that exception does not apply unless it is an intelligence committee hearing.
When was
So
the last Intelligence Committee hearing?
I don't think there was one.
Then why was the court right to apply that exception to let you search operational files?
Because the court found that the age of the records, the court could no longer, the government could no longer justify it being operational records for records that were up to 60 or 70 years old.
I'm sorry. So my understanding was that the search was based on the fact, on 3141C3 exception. Is that not accurate?
That is not accurate, Your Honor. I believe.
So you're saying that the search was authorized even though none of the statutory exceptions applied under Section 3141?
Yes, Your Honor.
So the district court.
I'm sorry. That exception did apply because
Okay, so then
we
what
had
was
submitted.
the last relevant hearing, because these allow the exception to the exemption of operational files turns upon the subject matter of investigation by a congressional the identified types of congressional committees or others, and which you said the last one of those was 1992.
Well, Your Honor, the court held that the exception was because we had presented evidence by members of Congress and senators that the records should not be continued to be classified held in the operational records files. That was the exception that the court applied. In any event,
Sorry, is that in the statute? Where's that in the statute that that's an exception?
excuse me?
Where did the statute? What part of the statute is the basis for allowing us a search of operational files in this case?
Testimony that
What part of the statute authorized, right? CIA operational files are off limits for FOIA unless you fall in one of those 3141C exceptions.
yes, Your Honor.
And so just telling me that somebody said something doesn't answer that. What I'd like to know is where in the statute the district court's basis for getting into operational files was. I thought it was 3141C3.
I believe that it is, but
Okay, then I'm back to my question. If the last triggering event was 30-something years ago, does it still apply?
yes, Your Honor. The district court ordered the CIA to search its operational records in 2017.
Mm-hmm.
So,
5 years after the last hearing.
yes.
So your reading is that there's no time limit. As long as you can find somewhere in history a congressional investigation into the topic you're searching for, you can get into the operational files of the CIA, full stop.
I believe so, yes, Your Honor. Getting back to the search, I would like to talk about the search briefly. I've reserved 2 minutes for my reply.
But even if they looked at the operational files, didn't they conduct a manual review after that and then still didn't come up with anything?
Apparently, they said that they conducted a review, but there was no description of the search whatsoever, with the exception of the terms, the search terms. And one of the search terms was Vietnam. Over half of the voluminous evidence that we have submitted had to do with Laos. They didn't even search that country, apparently. And insofar as the overwhelming evidence of overlooked materials, the Senate, the CIA provided the Senate with 1,400 firsthand live sighting reports which was returned to the CIA for processing, and they have produced not one of those. The Senate Select Committee said that there were 15,000 both first and secondhand live sighting reports. They have produced almost none of them. And over the 20-year course of this lawsuit, they produced approximately 100 live sighting reports, woefully inaccurate. I would also suggest that there's another item in this is the list of PNOK, primary next of kin, who authorized release of their loved ones, of information on their loved ones. Now the CIA had refused to do that. They said it was too much trouble, or it was unduly burdensome. The district court overruled them and asked them, said, no, you have to search. Then later in 2019, the district court said, you have to search your operational records. Well, the CIA did not search its operational records for those 1,700 names. We suggest to the court that if it was proper for them to search their non-operational records, it was certainly clearly important for them to search their operational records. And also, Your Honor, one of the issues that we brought forward was the motive for withholding the records that the CIA has. And I would suggest that Mr. Billy Hendon, Representative Billy Hendon, wrote a book about this. It's a very informative book, and he entitled it An Enormous Crime. I think that every single piece of evidence that the CIA knew that men were left behind after the close of the Vietnam War inculpates the CIA in an enormous crime, that is, abandoning its own citizens. Vice Chairman Senator Bob Smith, whose affidavit is in the record, wrote that what is really at risk are the reputations and careers of intelligence officials who participated in and perpetrated this sorry chapter in American history. I see that my time is almost expired. Thank you.
All right, we'll give you a couple minutes to reply.
Thank you.
Mr. Rayon.
Thank you, Your Honor, and may it please the court. Graham White for the CIA. The CIA has produced more than 8,000 pages of responsive records during the course of this litigation, addressing the fates of U.S. soldiers who went missing or were captured during the Vietnam War. The district court held that the CIA's search of its non-operational files was adequate under FOIA, and plaintiffs don't challenge that aspect of the district court's holding in this appeal. At issue here is a subsequent limited search of the agency's operational files for a specific subset of records that plaintiffs contend were allegedly shown to members of Congress in the 1980s and early 1990s regarding live sighting reports, aerial reconnaissance imagery, and records regarding rescue operations.
Is there any time limit on that? I mean, the statute doesn't suggest anything, but given the sensitivity of operational files, I take it you all haven't argued that that was sort of stale in the late 1919 or 2019 to be relying on 30-plus-year-old hearings as a basis for probing into operational files?
But the statute, the CIA Information Act, does not specify a time limit for the age of congressional hearings that could provide a basis for the exception under subsection C3. My understanding is also that the district court ordered the operational
Or
files.
50 years from now, someone could come look at your operational files again based on that same hearing.
Provided that the files are the subject of a congressional hearing regarding a specific intelligence committee specified in the statute.
The same thing here.
Sorry?
I mean, the same type of inquiry here.
Right. Well, there's nothing in the statute that indicates a cutoff date for the type of hearing.
I should know if there's any sort of staleness concerns.
We haven't raised that in this appeal, Your Honor, and the statute doesn't indicate any date range there.
So given that you agreed to do this search, why on earth did you not search the word Lao?
So the declarations provide a subset of the search terms that were used. They don't.
Where's a list of the full search terms used?
The declarations do not contain a list of the full search terms used.
How do
However,
we know if the search was adequate without knowing what search terms were used?
so the CIA has used this formulation describing a subset of the search terms that were used in previous declarations addressing operational file searches that it has submitted to this court in cases such as PORA, BCIA, and DBACO, the U.S. Army. And in those
And in
cases,
those, whatever terms we had by themselves were sufficient. So if we looked at the little subset you gave us and we go, there's no way that is remotely sufficient because you left out obvious terms like LAO or rescue,
so if we were,
then what do we do? How come, I don't know how we can evaluate the sufficiency of a search without having the search terms in front of us.
so even if this court were to assume that the search terms listed in the declarations were exhaustive, the search is still reasonable because of how broad the terms that were used were.
No,
here.
they're not. They don't get LAO. You have Vietnam, but you don't get LAO. And LAO is a big part of their FOIA request, and it is a big part of this litigation. And you're just not covering.
The terms that were used include POW, prisoners of war, MIA.
Yes, but you don't
image.
have anything about the country of Laos.
But the terms that were used would capture,
We don't know that. We don't know, since there wasn't a war in Laos, that these words would have.
well, any operational files that relate to prisoners of war, POW camps that reference the specific congressional committees.
They have
that
been
were-
called something different else in Laos. I don't understand. Why wouldn't you search for Laos? You said you wanted to do a nice wide, broad search. Maybe that's one of the other terms that's not listed. If so, you can tell the court that.
So
You didn't do Laos, you didn't do rescue, you did House Special POW, but not Senate Special POW, even though there were Senate hearings. This is not remotely a broad list. The subset raises more questions and concerns than it does assurance. It suggests, in fact, that it was, artfully narrowed the searching here. If you left out the term, was the term Lao one of the search terms or not?
the declarations don't specify it. I can't provide any more information
Okay,
beyond what is
then,
where in the
I
declarations
don't know
here.
how
But
we could possibly think that this is a sufficient search. And you're supposed to search about rescue operations. There's no rescue, there's no recovery, there's no word like that. This is a follow-up on a Senate hearing as well as a House hearing. There's no, for some reason, you have House Special POW. I don't know what that means, but you don't have any reference to Senate in here. I don't understand how this could possibly be, if this were the full list of search terms, how this could possibly be adequate.
any operational files that addressed prisoners of war, POWs, MIA, that were searched during the course
You
of
don't
the
know
search,
what they were
whether,
called in Laos because there wasn't a war going on in Laos. It was a CIA operation, so it might have not been called prisoners of war.
well,
We don't know.
the declarations also use the terms missing in action. But I would also just point
I
out, Judge Millett,
understand, but that's different from a POW or someone who's in captivity.
well, look, the court standard for whether an agency affidavit and subsequent search terms are adequate under FOIA is whether the list itself does not have to be perfect. It only needs to be
It's not,
reasonable.
but it has to be reasonably designed to capture the scope of the search. And this whole FOIA request was at least 50% about people who might be in Laos. And the Senate hearings were about that. And the district court specifically said, this isn't speculation that there are records about Laos that would have gone directly to the CIA. And so I don't understand how you can come in here now and say that skipping Laos, there's no reason to skip it.
Well, again,
No
I'm not,
logical reason, and the only reason to skip it is that you're not capturing certain records.
so again, Judge Millett, the declarations do not state that Laos was skipped, but even if we were to assume that the
Well, we
terms
have to
here,
assume, if these are the only terms that are before us, we can't assume there's any other terms. You would agree with that,
and
correct? You
if,
can't assume there were other terms. You can't just assume you covered terms that we are deeply concerned about you omitting.
well, the declarations state that other terms may have
I
been used. but-
understand.
Okay, yes.
Are you asking us to assume the critical terms that were in there?
No, what I'm asking the court to find here is that even if this list was exhaustive, it would have captured terms related to Laos because the terms that were here.
We don't have any way for knowing that.
Well-
I have every reason, there's lots of reason to think that it wouldn't.
Well, Your
And
Honor,
what term is going to capture rescue operations?
well, prisoners of war, MIA, image.
We don't know that things talking about rescue operations would use those words.
Well,
And I see one other thing too, when you use, and I just don't know how this works. If you have MIA, does that get MIA as plural?
So the declarations state that different combinations and variants of those terms were used.
But that doesn't tell me whether it gets singular or plural. Do we know whether, because it seems like you have MIA singular, but POWS plurals. prisoners of war, but I don't know about a singular prisoner of war. But I don't know if your computers automatically got plurals. But if just saying that variations on those terms doesn't answer that question.
Well, again, the CIA has used this formulation in other declarations describing operational file searches that this court held were sufficient. This
Cases where the terms provided to us were broad and adequate enough, but this one's got gaping holes given the agreed subject matter of the operational file search. And this one has gaping holes, obvious, stark holes in it, which the others did not. And we have a precedent that says if the search terms are not, if you haven't shown that they are reasonably designed to capture the requested information, then it's not, your search is not sufficient. And this is just, I'm troubled by the whole fact that there's a search of operational files to begin with, but you all haven't made an argument about that on staleness or anything, and maybe there isn't one. I don't know. But if we're there and you agree we're in FOIA land now, this doesn't strike me as possible that this is sufficient. It leaves big gaping holes in what was asked for, in terms that we have no reason to believe would capture that.
So again, Judge Millett, the touchstone of this court's inquiry is one of reasonableness. And because we're talking
It seems
about—
unreasonable not to have Lao in there when half the case is about people who might be detained in Lao, when those people might not be called prisoners of war because it wasn't a war in Lao.
So again, Judge Millett, I would just reiterate that the declarations state that these broad terms were used because they would capture more specific
Well, the fact
information.
that they say we think this will capture everything has never been the limit. I mean, we do have an obligation to look at the words you actually used and see if they make reasonable sense to capture the subject matter. And that's my concern on this one. And simply a vague reference to, oh, there are some other variations, but we haven't told you what they are. And there might have been some other terms, but we're not telling you what those are.
Well,
Seems inadequate to me.
well,
You
but-
haven't asserted that you need to do it in camera, that there's any security reason for not having done these other terms or not telling us what they are. So I don't know what we're supposed to do. It just seems to me that if you can come in and say, here's about half the words that are needed to cover the search topic, and trust us, there were some other words and some variations, that our exercise here is an empty one.
Well, again, Judge Millett, the language that was used in these declarations about different combination and variants being used, that is the same formulation that the CIA has used in these declarations.
Those formulations aren't what win your cases. What win your cases are the substantive words that you searched in those cases. We've never said that, well, the substantive words seem to fall way short of what the FOIA request is seeking. But because you had this inspecific language here about we did some other stuff too, you win. You don't have a case that says that. That's not what has won your cases. We have talked about the terms themselves.
Yes, no, I understand, Judge Millett. I would just reiterate that the terms that were used here, including image, I mean, again, we're talking about—
No, that's what's crazy. Like you search CIA operational files, all your CIA operational files, and you come up with a few that have the word image?
Yes, and there's a very good reason for that, Judge Millett. There are a couple of reasons for that. The first is that the agency engages in a decennial review process whereby every 10 years, agency staff review the content of exempted operational files to determine whether they still contain
In 10 years, you've only used the word, all the CIA operational files have only used the word image 3 times?
So if I could, so there's the decennial review process, right? And then also the CIA does not hold on to these records indefinitely. It operates under a records control schedule whereby the agency's operational and non-operational files are only retained for a certain amount of time. And so when we're talking about records, like what is the universe of records from the Vietnam War era, from the 60s and 70s, documents that are 50, 60 years old, the universe is quite of such documents.
But your search was of all files. That's the thing that flabbergasted me. My understanding was you weren't searching, that you didn't have a special subset of operational files called Vietnam War era. That in fact, you searched agency-wide all operational files.
That's correct.
Whether it had anything to do with Vietnam or with what's gone on in the world in the last 10, 15, 20 years. And you told the district court, by the way, that these operational files, time does not mean that these would not still include valuable and important information for the CIA. So that's the thing that's flabbergasting to me, that the word image. Now, maybe you don't use image. Maybe that's what the NSC does. Maybe you use the words picture and photograph. I don't know. I find it flabbergasting that the word Vietnam at most turned up a few times, not because of the war, but because this is the CIA.
So again, the CIA culls these files over time because of the decennial review process and the records control schedule. And the declarations do not specify precisely how many responsive records potentially.
We were told a few.
There were a few. And there's no requirement under FOIA for the
We
CIA.
were told a few, right?
That's correct.
That's what I'm reacting. I take a few to mean 3, maybe 4 records. Does a few mean something different?
Well, the agency is not specifying how many potentially responsive records they were, and there
Well, they
is,
told us a few. That has meaning. That's sort of a defined term, right? We understand what that means.
yes.
Okay.
But as for a precise number, the agency is not.
Well, if it was a dozen, we wouldn't call it few, would we? I mean, if the CIA would call a dozen documents few, I guess I'd like to know that.
I don't mean to be glib in my response. I'm just asserting that the agency deliberately did not provide the number of potentially responsive documents given the security issues here. We're talking about a search of operational files indicating the number of potentially responsive documents. Again, we're talking about operational files that implicate the agency's current viable sources and methods, and requiring the agency to specify or to describe the number of potentially responsive documents with any specificity could pose national security concerns because
Well,
it
then you
could.
can do an in-camera filing. But I mean, right now you've asked, and I understand at this point, we have to rule on the record before us. And that one is missing critical search terms. And the results seem, given there's some very broad words, but then there's an awful lot of words that would logically be in there that are missing, including particularly Lao and rescue. And I don't know why it's a House in there, but not the Senate. I just don't understand the logic of this list that we've been given here, given the nature of the request. And there may be good reasons, there may be explanations, but we don't have any of those. And I don't understand how we could say this is reasonable on a list like this, covers this much, when the search was supposed to cover this topic. That's all we do, is we match up the words to the topic. And usually there's enough words that they cover the topic, but there's no assurance on this list that anything having to do with Lao was covered.
So again, Judge Millett, I would just again point this court to declarations regarding operational file searches that it has held sufficient that did not include the
We
exhaustive
talked
list of
about the
search terms.
words. That's what's always done it for you, is the words that were used.
And again, I would respond that the terms that were used here would capture relevant information from Laos, like POWs, image, that kind of information was not limited to any country. It wasn't limited to any date range. So we would just assert that it would capture information regarding Laos. I see my time that has expired unless the court has any further questions. Thank you.
Mr. Clark, why don't you take 2 minutes?
Thank you for this additional time. The CIA says that it searched its records for the last 60 years using the term Vietnam and came up with a few records. That's just not, it's simply not believable. And Your Honor, at the end of our brief,
Have
we,
you ever filed a FOIA request with the archives?
excuse me,
Have you filed a FOIA request with the archives?
I have, yes.
Okay, because they say they've accessioned a number of documents to the archives, that these are old documents now, and that's where they might be, or they might be with other intelligence agencies.
We have a case pending against the archives before Judge Lambert for these records.
So that might be where they are. I mean, it's hard to know whether we're logically missing responsive documents if they're old. They say a lot of these things have been accessioned elsewhere.
Yes, the archive says they cannot conduct a search because they don't have the resources, and the records that were transmitted were not accompanied, or transmitted to the archives were not properly accompanied by indices.
I know, but so then how do we know whether really anything's missing here, as opposed to maybe somebody did a bad job of indexing things?
Well, we can speculate as to whether or not something's missing, but I would suggest, Your Honor, that in this search, the government has said that they have they named these rescue operations. There are like a dozen of them, or over a dozen of them. Those are CIA names. Now, if they wanted to find on these records, these records, they should have used their own code names to conduct the search. And we talked a little bit about imagery. In 20 years, they have not produced a single image And these images are very, very probative. They show codes that only the POWs knew that were on the ground. And we have evidence of the record there are at least 20 of those picked up, and not a one has been produced. And I would ask the court to consider this in the wherefore clause at the end of our brief. We asked them to list whether or not, to include in their declaration, whether or not their search would include repositories of communications with a number of other agencies. Now, it would seem to me they can answer that yes or no without any implications for privacy or.
FOIA is not a right to interrogate the government with deposition questions. You don't get to ask questions. You just have to ask for documents.
Yes, that is correct. I don't get to ask, take depositions. We could ask for leave to interrogatories, which are generally limited to the search, and that's exactly what we're asking. Why can't they say whether or not they searched repositories of communications with other three-letter agencies? I think that they could do that and without any implication for national security. Another thing is they should be able to say whether or not their search would include the repositories of presidential daily briefs. There are many, I assume, presidential daily briefs having to do with this particular issue, and they have produced for the last 50 years one presidential daily brief. It's just so. I think kind of ludicrous to suggest that they don't have the records that we are seeking, and their record of recalcitrance is 50 years old. The government talked about their decennial review, and there's an area of the brief where we talk about what they produce. It was up to, I think, 43 years later, after the record was created, that they released it after their decennial review. The last one, of course, was in 2015. So I suggested to the court that there are many deficiencies in the defendant's both production and bond index. Thank you.
Thank you. We'll take a brief recess.
The honorable court will now take a brief recess. Everyone must now leave the courtroom except for the attorneys arguing in the third case and panel law clerks.